able to announce, along with Senate President Bragg, that we've reached an agreement with Governor Lynch on the language of a constitutional amendment to address the New Hampshire Supreme Court's Claremont and Londonderry decisions. And I believe we passed out the language of that amendment, and the first thing I want to note for you as you look at that language is that it is straightforward and unambiguous. This amendment places a responsibility on the state to maintain a system of public, elementary, and secondary education. It also restores legislative discretion and flexibility with respect to public education that was lost in the Claremont and Londonderry line of decisions. The Claremont II decision, which was issued nearly 15 years ago now, the New Hampshire Supreme Court held that a legislature is required to maintain a state curriculum based upon a 1989 decision of the Supreme Court of Kentucky. This amendment overturns that aspect of the Claremont and Londonderry decisions. While the state will and should and always has had the responsibility to maintain minimum education standards, these standards will no longer be reviewed under this amendment by use of a strict scrutiny standard of review, which truly should not be the standard of review for legislative policy decisions, but rather the standard of review will be reasonableness, rational basis. Anyone going to court to challenge the public standards established by the legislature will carry the heavy burden of proving that those standards are unreasonable, that they aren't rational. This is a vast improvement over the Claremont and Londonderry decisions. As a practical matter, this will mean that the legislature will treat education funding along with an entire spectrum of very important funding priorities across the state, such as transportation, law enforcement, and social services,